Hi, my name is Natalia Willette, and I am a real estate attorney here in the state of Florida. And today we're going to talk about what happens if you are renting property and you happen to come across a service member. How do you have to respond in terms of the rental application as well as terminating the tenancy? So, members of the armed forces, service members, they are protected not only through federal law but through the state of Florida. So chapter 83.6, 682 and 683 of the Florida statutes are the ones that talk about the service members and how you have to treat them. So briefly, 83.683 is the one regarding applications. So if they complete an application for tenancy, then what you have to do is you have to, within 7 days, promptly review it and promptly either accept it or deny it. And if you are denying their application, you have to state in writing the reason for the denial. Otherwise, if you fail to give that notice in writing within that 7-day period, you have to rent the premises to them. So it's very important that you do your timely written notices to service members. The same thing goes for homeowners association, condominium associations, cooperative associations. If they have a requirement that tenants fill out and complete a rental application, the HOA is also required to give that, to review it within the 7-day period and to give a notice approving or denying the tenant within that 7-day period. If they fail to do so, then the same thing happens. The owner of the property can and must actually lease those premises to the service member. So that's something very important to keep in mind. And that provision of the Florida statutes is non-waivable. So you cannot write it out in a lease agreement. You cannot write it out in restrictions of the association or condominium. That's just fixed. So second part regarding service members, terminating the agreement, terminating the lease. So service members are allowed to terminate their leases early, so long as they provide timely written notice. And timely written notice means that they must give notice to the landlord that they are terminating their rental agreement with at least 30 days from the date that notice is provided to the landlord. That rent due is going to be prorated to that date that's on the notice for termination. And so what are the reasons for which they can terminate? Well, it has to do mostly with like a radius. So if the distance from which they're being ordered to move becomes more than 35 miles from that location, then they are allowed to terminate. Similarly, if they've been discharged and their home is more than 35 miles from there, they're also allowed to terminate. If they've been involuntarily discharged or discharged prematurely and it's within that same distance, then they are also allowed to terminate early. So those are things that you have to keep in mind. You will come across service members. Be aware of the factors. Be aware of chapter 83.682 and 83.683 of the Florida statutes. Good luck out there, investors.